There is no constitutional barrier to pushing through or nominating and confirming a Supreme Court justice right now, as close as it is to the election. Even in a lame duck period, it can be done. There's no, the Constitution does not forbid this. And yeah, I completely understand this idea of the claims of hypocrisy. I think there's something to that, right? I mean, it wasn't 3.5 years ago that we were, in this same boat. And we have all these senators on record then saying, oh no, we do the same thing if it happened again, and here we are. As far as norm violations, I think we've seen that across the board in American politics. And it's not something that's new to the Trump administration by any means. Harry Reid, a Democrat from Nevada, is the one who first went nuclear, lowered that threshold for the filibuster to a 50 simple majority vote confirmation for lower court nominees. Constitutional hardball is actually really interesting. So, like I said, nothing in the Constitution that forbids this. It's more of respect for norms. And so constitutional hardball is you're honoring the black and white letter of the Constitution, and maybe you're doing things that are, disrespecting longstanding norms. We saw that happen in the Bork nomination. We saw that happen again with Harry Reid going nuclear for the lower courts, and then McConnell going nuclear for the Supreme Court finally to get Gorsuch through. And now, of course, we're seeing proposals for things like court packing. We're going to add seats to the court. Along those same lines, there's nothing in the Constitution that says that the Supreme Court has to consist of 9 justices. In fact, it's just a law from Congress that makes it so. This is supposed to be a co-equal branch of government. This is supposed to be 1/3 of our government. And it's being treated as a slippery political football by the political actors here. Out of all the justices, they probably don't care about the court's legitimacy to the same degree. And so this is a matter of variation, right? This is and if there's anyone who cares about it the most, it's definitely John Roberts. John Roberts has proven himself time and time again in his position to be an institutionalist, just the same way Ruth Bader Ginsburg was. But she was in the dissent, right? So now she's gone. I also wouldn't be surprised if Roberts or the court in general issued some sort of statement about what's going on, because it's really getting to the point now where the court is just being tossed around. I think it is going to be a mobilizing factor. I think it's not only what's happened with Merrick Garland and now Ruth Bader Ginsburg, but it happens to be Ruth Bader Ginsburg's reputation, both culturally and as a legal scholar. I mean, so one thing I will say about Ginsburg is that her reputation is well-deserved. Whether you agreed with her or not, if you disagreed with her, her opinions forced you to do a better job. They were just whip smart. And culturally, we all know the notorious RBG, right? And so I think that impact is going to actually matter. But we'll see. I would rewind back to Justice Black being discovered to be a Klansman, right? The reason the Senate started holding transparent and public hearings was because of the public's backlash to that. Hold your agents accountable. Your agents are the folks we send to DC. They're our agents. We're the principals. The system is designed for us to tell them what to do. And so it might sound a little quixotic, but I do think that it's worthwhile.